I'm sorry for the inconvenience of coming over here. This statement will be brief. I appreciate the sheriff for providing us a space. Is everyone ready? All right. My name is Alexis King. I'm the district attorney here in the 1st Judicial District. We just met online with the court and counsel on the Aguilera-Mederos case regarding the motion for resentencing filed by my office. We have another court date that is now scheduled. It is set for Thursday, January 13th at 1:30. Barring a COVID issue, we expect to be in person. The defense requested more time and the court had questions for both of us. We'll be providing more information prior to that court date. Y'all, this is an exceptional case and it requires an exceptional process. In finding its verdict, the jury recognized the extreme nature of the defendant's conduct, which warrants a prison sentence. The defendant caused the death of 4 people, serious bodily injury to 2 others, and the impact of his truck caused damage to many more in our community. Knowing all of that, my office started the resentencing process the same week the defendant was sentenced, so that the court could consider an alternative sentence that was not bound by mandatory sentencing structures. Given the conduct and in consultation with the victims and survivors, we will likely be recommending a sentence of between 20 to 30 years when the court is ready to go to that hearing. We have and will take the necessary steps for the court, who is the most informed about what happened in this case, to strike the appropriate balance when considering a new sentence. I understand and appreciate the frustration of those wanting an immediate result. I do. But I ask for your patience as we take steps provided for in law as we consider a new sentence. I look forward to communicating more freely once this case has reached its conclusion. Thanks so much, everybody. Take it easy. Have a great day.
Thank you, everybody, for coming out today. If you have any questions, you can send them to me via email about process.
Okay, so we just had the press conference of the district attorney for Alexis King. She is the district attorney in the 1st Judicial District. And this was in regards to the resentencing that was started in regards to the trucker with the 110-year sentence. And let's do a quick recap, and then I'll give you some thoughts specifically as it relates to the law here and why nothing took place today, because I don't think legally that can take place. So, as for those who are not familiar with this case, Rohel Aguilera-Mederos, he received a 110-year sentence for causing a 28-car crash that killed 4 people when he lost his brakes coming down I-70. Now, a lot of people think that this was simply an accident and he shouldn't have been charged with anything. But there was evidence, in fact, his own testimony, that he knew the brakes were, and when I say testimony, his previous statements were that he was had issue with his brakes, he had called his boss, etc. Needless to say, he was the only one that was charged in regards to this. No member of the trucking company was charged in any way. Needless to say, 110-year sentence. Some people were upset by this. They started a petition, and now it's up to, I think, 6 million people basically requesting that the court reconsider the sentence of the 110 years, or in the alternative, to have Governor Polis provide clemency. Some people are saying down to time serve or a much reduced sentence. So let's explain how we got here. First, the district attorney could have charged basically careless resulting in death, or they could have charged nothing at all. But they chose to charge vehicular homicide, basically extreme indifference, a complete disregard for a danger and human life. Basically, extreme indifference is kind of like, man, I know this is a dangerous situation, but hold my beer. I'm going to go for it anyway, right? That's really extreme indifference. You have to recognize that there is an actual risk. The classic extreme indifference, if someone was to, shoot a firearm into a crowded room just indiscriminately, extreme indifference to human life, chances are you're going to kill somebody. So in this particular case, the prosecution charged 41 counts, careless driving, all the way up to vehicular assault, and then they charged first and second degree assault. And if anyone should be upset with anyone in this particular case, I think the district attorney's office completely overcharged this case. And that is what resulted in the injustice that took place in the sentencing, if you think it was an injustice. All right. The district attorney, although Alexis King was not the prosecutor at the time this incident happened, because it goes back to 2019, and there were delays because of COVID and some other lawyer issues in this particular case. The original attorney that was on the case got suspended and has ultimately been disbarred, so new attorney had to step in, and now he's on attorney number 3. Anyway, the crimes of violence that were charged were first-degree assault. Usually first-degree assault is when somebody shoots or stabs somebody with a weapon. You basically are intending to cause death or serious bodily injury. And that's what the jury basically concluded. And you have to remember, a jury, 12 people, concluded that the charges that were brought were basically appropriate and that he was found guilty of that. I think it was overcharged. Think about a case if somebody has been charged with let's say a vehicular assault. Let's say they were intoxicated. Okay. Well, there's a crime for that. It's called vehicular assault. You were drunk and somebody suffered serious bodily injury, a break, a fracture, a loss of some sort of organ or something to that effect. Well, there's a specific crime for that, just like there's vehicular homicide. You don't go charging first or second degree assault saying that that person intended to cause this crime. They intentionally used it as a deadly weapon. Okay. It's just a bad accident and people got hurt. And that's the way the legislature has made a specific count. So basically you can't charge it. Now, on the other hand, there was the case up in, was it Minnesota, I think recently, where the guy drove through the parade. Clearly a first degree assault charge would be appropriate in that regard, even attempted murder in that regard, because he used that vehicle as a deadly weapon with the intent to cause death or serious bodily injury to somebody in that regard. So that's where it is. Now, Alexis King, she wasn't the elected DA when this happened. She is. I've had cases with Alexis King. She was always very, very reasonable. In this particular case, though, she was the elected district attorney when the case went to trial. The district attorney could have said, Judge, we're dismissing the crimes of violence all the way up until the time that the jury got the charging instructions. The jury, when they went back to deliberate. The district attorney didn't do that. So then on top of that, you have the district attorneys posting on Facebook of their award that they created for this particular case, saying here's a brake pad, the I-70 case. Kind of shows that it really may not have been about justice. It was more about winning, right? Now, is Mr. Aguilera-Mederos completely without fault here? Well, let's face it. He gambled and he lost, okay? Now, district attorneys overcharge cases all the time. They do that as a plea bargaining tool. I can tell you, you say, I'm going to go to trial. Next thing you know, DA looks at a case and says, I'm going to add 6 counts. And you're like, are you kidding me? Why didn't you charge those before? Guess what? The DA can add counts just like they can dismiss them literally up until the trial starts, okay? They can dismiss them up until the time the jury gets the verdict or gets their charging instructions to go back and deliberate, So Rohel Aguilera-Mederos, he basically said, hey, I'll accept responsibility. I'll take a traffic ticket. Basically, like I'll take a faulty vehicle or something to that effect. The plea bargain in this case, I think, was 20 years from the district attorney's office. He said, hell no, I'm going to trial. Let's face it, his first attorney, his second attorney, they all probably told him, if they didn't, they got real problems. I'm sure they advised him that this was mandatory sentencing, crimes of violence. The victims at sentencing, the sentences would have to run consecutive, one after another. And so when you have 4 first-degree crime and then 6 second-degree assaults that all stack up, 10 to 32, get 10. You got 40 years on the death cases right there if you just give the minimum. And then the other people start adding up. It's all consecutive by statute, which means the legislature has done that. So then what takes place? Alexis King, something I have never seen before in my life, the district attorney herself files a motion to reconsider, saying, we think this sentence was too harsh. I have never, in 26 years, going on 27 years, never ever seen a district attorney say, wow, that sentence was just too hard. We really feel sorry for the defendant in this particular case. Never ever seen it. Now, what does that mean? It means that what it comes down to is that now it seems like it's a more political process than justice being blind. So here's the tricky thing. The district attorney filed a motion to set the matter for a reconsideration hearing. Now there's a statute. The statute is, and this is getting really in the weeds, but it's Colorado Revised Statute 18-1.3-406, mandatory sentence for violent crimes. And that's what these crimes were considered. Frank, can you put this up on the screen here? So we'll put the statute up just so everybody knows that what I'm saying is factually correct. Now, let's see if I can get this zoomed in or focused here. All right. Here we go. Focus that. That doesn't really help, does it now? All right. Well, let me just say it. So the mandatory sentencing for a violent crime. It says any person convicted of violent crime shall be sentenced pursuant to 18-1.3-401 to the Department of Corrections for at least the midpoint of the presumptive range. Blah, 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 blah. And they can't do a suspended sentence. It says except, because what do we always say? There's always an exception to the rule in law. It says except that within 91 days after he or she has been placed in the custody of the Department of Corrections, the Department of Corrections shall transmit to the sentencing court a report on the evaluation and diagnosis of the violent offender, and the court, in a case which is considered to be exceptional. Remember that key word she said? This is an exceptional case. She's read the statute. An exceptional case, or exceptional, and to involve unusual and extenuating circumstances, may thereupon modify the sentence effective not earlier than 119 days after his or her placement in the custody of the Department of Corrections. So by statute, the court could not have done anything today. I think they would have been violating the statute. Now, the district attorney is one that filed this motion, and they said it for extenuating circumstances and exceptional circumstances. Well, what is new or different about this facts of this case that the district attorney did not already know when she filed the case, when she proceeded to trial? Absolutely nothing, other than 6 million people have now, signed a petition and are up in arms that they think the sentence is too much. And then it goes on and says, so after the 119 days, the person has to be in custody. Such modification may include probation if the person is otherwise eligible, therefore. Whenever a court finds that the modification of the sentence is justified, the court shall notify the state court administrator of his or her decision and shall advise said administrator of the unusual modification. The state court administrator shall maintain a record and shall be open to the public. So that's the statute that the district attorney and the judge and the defendant are going to be relying upon. As you can see, first of all, one, I've never seen a DA file this motion. Two, I've never seen a hearing granted on this motion because it just doesn't happen. If somebody's convicted of a crime of violence, the judge sentences people, they're on their way. Never have I've heard judges say, well, yeah, it seems a little excessive, maybe a little high, but that's the law. Do with it what you may, but move on. My job is done here. Go appeal it. If you think something's was wrong with the sentence, then you can, maybe you'll get some relief. So the judge couldn't do anything in this particular circumstances anyway, because the report has to be done. Now understand, Rohel Aguilera-Mederos was only sentenced less than 2 weeks ago. Okay? So I don't know if it was the district attorney's office that called the Department of Corrections or whether it was the governor's office that told somebody at the Department of Corrections, obviously it falls under the governor's control, and said, get this report done now. Because normally the DOC is given 90 days to do that, and they did it in 2 weeks. Absolutely unprecedented. Once again, makes it look like, wow, does everybody get this kind of special care when they get sentenced with a crime of violence? No, which makes you think that, well, it's political. And what's wrong with political when you get to court? Well, it makes it seem like it's not fair to everybody else who has been similarly situated. So that's where we stand. Now the new court date has been set for January 13th. Apparently the court must have read the statute and basically said, how am I supposed to do this until he's even served 120 days in custody, right? Now, the governor's office has set up rules for their clemency, and the governor's office on their clemency board, what happens when somebody seeks clemency is you usually go to prison or you've been out of prison and a bunch of time has passed and you say, hey, I've been a good person, please reduce my sentence or completely pardon me from that. And the governor set up a board, they kind of screen everybody and then they send everything off to the governor to review. But normally somebody's in custody has to have at least served 1/3 of their sentence until the governor's supposed to do that. So if they follow his own rules, on a 110-year sentence, he couldn't even consider it until about 32 years from now. And obviously our governor won't be in office in 32 years. So it just, obviously if something unjust took place, but I mean, some people think the sentence is appropriate. I mean, the families of the deceased people have come out and said that 110 years seems just fine with me. He engaged in this reckless conduct, and this is what happens when you do that. The legislature wrote the laws. They collectively represent the people of the state of Colorado, and they said that this was an appropriate sentence. Mr. Aguilera-Mederos, you gambled, you lost, right? Some people think that. Other people think, it's unfair, just go and undo it. But like I said, had this not received some special attention from social media influencers, I think Kim Kardashian got involved. If this thing had not blown up to be a political hot potato for the district attorney, I guarantee you there would be nothing else taking place. And when it becomes political, then it looks like, well, special rules for special people. Now, I think the sentence is extremely excessive for this. I mean, I get it. He was engaging in conduct, but I still think 110 years is a little extreme for what is really amounted to a traffic accident. It is not as though he intended to get into that vehicle and drive down there and say, I'm going to start killing people. He didn't do that. Do I think there's some DOC time is probably appropriate? Yes. But 110 years, I don't think that's appropriate at all. So that's where we are today. Brought you the update. The hearing was not put on WebEx, so we couldn't bring that to you. And even if it were, here in Colorado, attorneys cannot rebroadcast that. So I don't want to lose my law license to do that. So we'll just have to give you the analysis that breaks down. So hopefully we did that. Next court date for Mr. Rohel Aguilera-Mederos is January 13th at 1:30 p.m. We'll be there. A lot of things need to take place. And apparently the defense did not have any objection because I think by statute the judge couldn't do anything today, even if he wanted to. So, all right, that's all we got for you today. Thanks for watching. We will see you next time on Crime Talk.